Welcome, welcome, welcome. It's DC the Blacksmith. This is my continuation of the saga that is the confirmation hearing in consideration of Judge Katanji Brown Jackson for the United States Supreme Court. Okay, so this one's going to be quick. On Monday, believe that was March 27th, 2022, the Senate Judiciary Committee reconvened very briefly um, in extension to the confirmation of Judge Katanji Brown Jackson. They opened, Dick Durbin opens, and he gives a few remarks. He basically repeats that for the most part, the senators were well behaved, but a few of his colleagues participated in what the phrase of the century, jackassery, as coined by Senator Ben Sass from Nebraska. Y'all, that's going to get me in trouble for the rest of the year, I swear. But he reiterates that for the most part, he thought that there were meaningful exchanges and everyone conducted themselves as to be expected, which overall, I think that the conduct, I would have liked to see better conduct all around on both sides, including this hearing and past hearings. I just feel like someone made a point that when she was confirmed by the same body, same Senate Judiciary, same members, when she was confirmed by them last time, the only difference was there were no cameras in the room. And I personally, if cameras are going to make people act like that for a soundbite for their campaign ad, then I'd rather just listen to it. But that's neither here nor there. That's not the most important part. Um, Dick Durbin, continuing, he rebukes the attacks on Katanji Brown's character, and he reminds everybody of a correlation between the things that Katanji Brown Jackson declined to answer and those same things that Amy Coney Barrett also declined to answer when it was her hearing. Then Chuck Grassley speaks. He's the next ranking member. He joins, and I guess the other senators had submitted a request to hold the nominee for 1 week, hold consideration for 1 week, or postpone, stall, whatever. But Chuck Grassley joins in that request. He said that the record is not complete. Um, I don't know if they're still talking about those pre-sentencing reports or what, but he says there's some things that they have yet to receive in the record. Or another alternative could be there are some things that have been requested, they've yet to receive them, and there maybe hasn't even been sufficient explanation why they haven't received them. They can disagree with the reason of why they haven't received them, but I suspect, and I don't know this for sure, I suspect that if they request something, the Senate Judiciary requests something for the record and they're denied in that request, the normal course of business, I don't know whether mandatory or not, but the normal course of business is probably to um, submit some type of reason or explanation, just explaining why. Uh, Continuing with Senator Grassley, he brings up that the Democrats in the past, and he particularly points out Joe Biden, has voted for candidates at the district court level and then not supported them for their Supreme Court nomination. So he says, they want to go down that road. We can, but it's happened on both sides. Fair is fair. It's happened on both sides. It's happened on both sides. Don't bring me stuff that happened 100 years ago on one side and hasn't happened since now. But hey, if it happens on both sides, it happens on both sides. And then he comes back to his point about the incomplete record. Oh, he does say they're missing the non-public. He particularly points out that they're missing the non-public sentencing committee reports. Okay, they're non-public. There are some things that are non-public, but certain bodies can request them, and then there are certain things that are non-public, non-requestable. We're not turning it over unless it's a matter of national security. So if it's non-public, it's non-public, but whatever. He says that this was these non-public sentencing committee reports are back from the Obama White House. I don't know if that meant that the Obama White House classified them, for lack of a better words, or made them non-public or dictated that they become non-public. The sentencing committee has been around since before the Obama era. So I would like to know to what extent that these have always been non-public, or is it the case that we've never had a candidate who participated in this type of practice, maybe? So we've never had to make this type of request before. That's entirely possible, but I would like a history on to what extent have these always been non-public and unrequestable. I'm just curious. I see plenty of reasons not to submit those or whatever. He talks about the child sentencing that kept coming up, and he just says that, that was a part of her record, and we as a judiciary committee are charged with reviewing the record, and she was in practice and those things were part of her record. I understand that, but there's a difference between disagreeing with someone's position and not recognizing the logic behind it. And some of those questions were, this nominee explained logically why the sentencing was the way it was. She gave a logical explanation, and you don't have to agree with it, but to act like, oh, she's just doing this because she's soft on this. No, she gave a logical explanation. Now, you can go the opposite with it. That's fine, but it's not like she's just doing anything she wants to do. There's a reason behind this, and it sounds like she's not the only one in the country doing this. So at some point, it does become, I don't know if I'd go as far as to say it becomes an attack, but at some point it becomes disingenuous, I think. Then continuing with Senator Grassley, he says that in regards to judicial philosophy, he says that Senator Schumer was the first one to publicly make judicial philosophy a means of opposition 2 decades ago in the consideration of Janice Roberts Brown, or Roberts Brown, I think is her name. Again, if it happened, it happened. Fair is fair. I just am the type of person that I don't say, oh, well, that person did it, so that's the reason I'm gonna do it. If you know it's wrong, if you know it's not in keeping with your character, keeping with your beliefs or the moral fiber of your being, then why would you do it? Regardless if everybody else is doing it, it's the old, oh, if everybody else is jumping off a bridge, you're going to jump off the bridge too. Now, I was a little bit of a smart aleck, and my response would always be, well, where's the bridge? How high is the bridge? Do I get anything that benefits me from jumping off a bridge? Because there's all types of bridges. You see little bitty bridges that go over a creek. The bridge might be 7, 8 inches up off the ground. Somebody say, oh, if you jump in the creek off of this bridge and get your socks a little bit of wet, I might give you this $100 bill. I'm not saying I would do it. I'm just saying I like to know. You ask me when I do something, I like to get a lot of the facts. I just personally like to assess the situation in full. But it's whatever. But back to the point. The point is, it's disingenuous. It is telling that you don't believe what you say you believe when your excuse for doing something is, well, they started doing it, so we followed. So now you're a follower. So you really don't care. You don't believe anything. They start doing it, you start doing it. No. If I know something is wrong, if I know that goes against who I am, what I believe, that's not a tradition that I want to uphold too, I don't do it. I don't care who doing it. I don't do it. So after Senator Grassley speaks, they adjourn the meeting to reconvene later, but then they reconvened real quick, right back up because a few senators had remarks. So when they reconvene immediately after they adjourned, Senator Whitehouse speaks, and he says he wants to speak in particular to Eleanor McCullen. Remember from my review of day 4, the witness testimonies, Eleanor McCullen was the anti-abortion activist, and the case regarding buffer zones in Massachusetts were, I don't know if her organization was directly involved, but that's what she spoke to. So he starts off that she's a lovely lady, and if it repeats kind of the same thing I repeat, if she says that that wasn't the environment during the day that she was there, then he has no reason to believe that she's telling a mistruth or an untruth about that. But he goes on to say that he wants to give a little bit more insight to what was going on. He said that in Massachusetts and in Rhode Island, these buffer zone laws were passed in the 2000s. And it was in response to events that kept happening at these clinics, particularly in Massachusetts and Rhode Island. And he said these clinics had to recruit volunteers to safely escort people into the clinic. Now, before I move on with his point, I'm gonna have to put a pin in that. And I'm gonna have to explain something. What I don't understand is, are these not private property? First of all, a clinic is a clinic. You can have a clinic for all types of things. You can have a clinic for ED. You can have a clinic for mental health. You can have a clinic for a number of things that people might not want to be bothered, for lack of better words, when going into the clinic. Any reason someone is going into a clinic, to me, if it is a lawfully operating clinic, to me, this is a clinic that's passed all health inspections. Nothing illegal is going on in this clinic. It really is nobody's business about you going in the clinic. And if they protest the events that take place in the clinic, deal with that somewhere else, not about the people who have lawfully decided to seek treatment for whatever it is in the clinic. How about we start going outside of ED clinics and filming and harassing the men's and calling them all types of things? How about we start doing that? Because we don't like it. We feel that, promotes X, Y, and Z. I just think sometimes people need to take a step back again. If you have morals and things you believe are right and not right. But my other point was, are these not private properties? Because my legal understanding of private property, and each state controls the property, the status of the property. So states control their property rights within reason, but overall there's certain property rights that just everybody kind of has. In general, you would bank on having no matter which state you're in. And one of them is you can kick people off of your property, whether it's a business or a home. So what I'm not understanding about these clinics, when you buy the property and you just put a parking lot in the back, so now people have to drive in the back, which is private property, to enter the clinic. And that's it. Nobody can come in the parking lot because it's private property. Maybe I'm oversimplifying the issue, but if these clinics are private property, I'm not seeing what the issue is about kicking people off of your private property. And I'm also not seeing, why are y'all having that big of issue with getting people onto your private property and into the door? Did you not buy enough private property? Do you not own the parking lot where people park in the back? Y'all have been to doctor's offices where the office is in the front, it looks like a house, and then you drive in the back with the parking lot, and then they might even tell you that the entrance door is even around back. Usually they own all of that, so nobody would be able to enter the parking lot either because it's private property. And my other thing is, if these are not private properties, then these celebrities and things, abortion, pro-choice advocates. It's some celebrities that speak out against this. Y'all aren't putting y'all money where y'all mouth is. Are these not private properties? That's just my general question. And why are they not private properties? What's the funding issue? Why? But that's just me. So then he goes on to talk about that Senator Whitehouse, this is who I'm recapping right now. He was a U.S. attorney at the time. He said a man went into one of these clinics and with a rifle shot people and killed people. I don't know if they killed people, but that's my implication. But he shot people in the clinic. And so this happened again in another locale. And he says that he was calling the National Guard. He said, look, y'all need to get out there and protect the people that are walking in the clinics and do security. And the National Guard, they basically said, we don't know if we're allowed to do that. Now, back to my point about private property. I'm thinking that the reason that they weren't allowed to do that is because it was private property. So I go back to what extent do you not own it, ad colum? Do you not own it from the ground all the way up to the sky? Are you renting? Like, what are you doing? What are you doing? Even renters have right. If you rent something, you act, for all intents and purposes, that is your property while you're in it. But so the National Guard said, we don't think we're allowed to do that. So then Senator Whitehouse said, well, are y'all allowed to protect me as a U.S. attorney when I go places? They said, oh, absolutely, we can do that. So he started going to the clinics and taking, walking with people, because if they're protecting him and he has people in very close vicinity with him, then by free rider, everybody gets protected who's close to him, because he's allowed to be protected by the National Guard. So they protect him. And he said that this was an environment before those buffer zones, those 2000 laws that were promulgated in 2000. And he said he just wanted to provide more context to Eleanor McCullen's testimony, that maybe when she was there, it was more of a wholesome protest environment, which again, I said it in my last video. By virtue of her age, I believe that if she was at an event, then the event was calm, like how she described it. Just because, what she got to lie for? You know what I mean? Like, who does she have to answer to? She's a private citizen. She's paid her dues in life, lived her life. Who does she have to answer? She has no reason to come up there and act like, I just don't see that old woman being somewhere where people are acting out. But hey, I'm sure it happens. I don't mean to age shame anybody, but I just choose to believe her. So Senator Whitehouse wraps up his statements, and then Senator Blumenthal speaks, and he says he also would like to provide some more context. He said at the time that the brief was written in regard to the buffer zone case that Judge Katanji Brown Jackson worked on, he had wrote a brief on behalf of, they say U.S. attorneys generals. For some reason, that doesn't sound right to me, but everybody says it, so it must be proper English. To me, I say it, U.S. attorney generals. Right? United States attorney generals. They say United States attorneys general. I'd rather say United States attorneys generals. So I'd either put the plural on attorneys and generals, or I would put the plural on just generals, with the implication being that attorney general is the phrase that I'm making plural. They put the plural on attorneys, but not general. I don't know. I'm not about to look it up. My Schoolhouse Rock conjunction function days or way in the past, I probably am saying it wrong, but it just sounds more wrong to me. Whatever. Then Senator Klobuchar speaks, And she says that she's the Democratic senator from Minnesota. She says that in her locale, there was actually a explosion of a clinic, or attempted or carried out explosion of a clinic. And she said a private citizen sent her a bulletproof vest because she went out to the clinics, and that's just what the environment was at that time. So no one else gave any remarks. No one else spoke, just Dick Durbin, Grassley, White House, Blumenthal, and Klobuchar, which I was surprised at that. And, I'm sure everybody appreciated the short hearing. I'm sure the senators themselves appreciated the brief hearing. I'm sure they're busy doing other hearings. Notice I said other hearings instead of passing laws, but I'm sure everybody appreciated the briefness. But I was, I wish that, just in the interest of uh, information, that maybe one of the Republican senators had just mentioned something, um, just in the interest of getting a little bit, getting on record another position as well. And then you guys and me can get both positions and infer. Anyways, that is just keeping you guys updated on what's going on with the confirmation hearing. I think a vote by the Senate. So the next steps would be a vote by the Senate Judiciary Committee. That vote is on whether or not they're going to send her nomination to the entire 100 senators. And then after the judiciary votes, then they'll go on to the entire floor of all the senators, and the senators will vote. And if I remember correctly, I think that when they come back to the judiciary to see if they're going to advance the vote to the entire Senate, I'm pretty sure that they all speak again briefly. And so I'll probably be back for that recap and review. And I'll be back maybe for the final vote, or maybe to give a poll for the final vote to see, how it shakes. There's expected that she has enough votes by Democrats alone for her nomination to pass. Everyone's just trying to see if she'll get any bipartisan support from the Republicans. I suspect that she'll get a few votes, even coming out of committee. I suspect that a few of the Republican senators that I mentioned were very thoughtful and had substantive and meaningful exchanges with her. I suspect that a few of them might vote her out of committee. But the ones that were, it's the jackassery of it all, those ones probably won't. But did we expect them to anyway? Anyways, that's my take. Until next time, please visit nrayblog.com. I think I did it right to where it's scrolling across the screen. That's www.nrayblog.com. Have a great day. Stay informed.